Hello, Colorado Realtors. Thank you for joining us for another edition of Legal Bites. I'm Scott Peterson. So today on Legal Bites, we're going to be talking quickly about a really important topic, probably the most important topic I'll ever talk about. And that topic is, how do you get paid? It's important because I think a lot of you probably don't think about it, primarily because most of you are doing business through the MLS, and primarily in doing business through the MLS, you're doing business within your own MLS. And that's the nice thing. In MLS, your rules and regs mandate cooperation between parties, and so it is a unilateral offer to compensate. So if you're doing a transaction with a buyer, bringing a buyer to a home that's listed through the MLS, that listing in the MLS creates a unilateral offer to compensate somebody that brings a buyer and completes a transaction on that particular property. So in those cases, commission agreements, other things aren't necessarily so incredibly important. Well, they're not important to get because the two parties' mutual membership in that MLS creates the offer to compensate. And there's an expectation of payment for closing a transaction. If you're doing deals within your MLS or within other MLSs that your MLS has a partnership with, then that applies, and there's no commission agreements or any other writings or documentation that's necessary to do that. And that's going to be a lot of your transactions. Lately, I've been getting more and more questions, people straying outside of their MLSs. Maybe somebody's going to do a deal up in the mountains or something with a friend or client down here, and neighbor's going to buy a second home up in the mountains, and they're going to be participating in a transaction that is not within their MLS or an MLS that they have a partnership with. So, and another example of that would be a for sale by owner situation where property is not listed on the MLS, maybe a pocket listing where it's not listed on the MLS, any kind of commercial transaction which is probably not going to be listed on the MLS. All of those scenarios do not create any offer to compensate. There's no promise to pay, no offer to compensate on the part of the listing. So you can't expect payment for a commission in that case without some sort of a writing that's in place. All right? So I do get questions, and most of you good realtors know that you can't put commission considerations or provisions that are personal to the broker in the additional provisions of the contract to buy and sell. You're not a party to the contract to buy and sell, and provisions that are specific to you shouldn't go in there. There's a quick little exception if you're representing a buyer and in your exclusive right to buy agreement with your buyer, you have checked the box in 7.3 that says that the buyer does have it, the seller may pay, but buyer does have an obligation to pay. In that case, you can put commission considerations in your offer, in your contract to buy and sell, because it does benefit the buyer in that case. In other words, if you're not paid by the seller in the transaction, then the buyer does have an obligation per the exclusive right to buy to pay you, and so it does become a consideration or a provision that benefits the buyer in that case, in which case it could go into the additional provisions. But kind of a limited exception, because most of you probably are checking in your exclusive right to buy agreements with your clients that the buyer does not have an obligation to pay. It's the seller's obligation to pay. And if that's the case, then it should never go into the additional provision. So do not put it there. What you're going to want is some sort of a commission agreement, some other independent writing between you and whoever you're expecting to be paid by, whether it's the seller in an FSO, a for sale by owner situation, whether it's the landlord or other agent in a commercial transaction, or something that's a pocket listing that's not in the MLS. You need a separate writing. Okay, so some sort of a commission agreement. If you're going to do a commission agreement, it's very simple. You're a party to that agreement, so you can actually draft the agreement if you'd like to. It doesn't need to be real complicated, but you do need some written evidence of the payor's desire, willingness, and acceptance of responsibility to pay you for the completion of the transaction. All right, so if you're going to do a commission agreement, you're going to clearly have the parties' names that's listed in the commission agreement, what the property address is, that you're going to be representing a party in closing on. The condition of payment, typically that's going to be upon closing, certainly in a sale transaction. In a lease transaction, it might be a little bit different, but in a sale transaction, it's typically going to be on closing. Who's going to pay the fee? Is it going to be the seller? Is the fee going to come from the listing brokerage, some other party? Who's going to pay the fee is an important consideration there. How much is the fee going to be, of course, is incredibly important to memorialize in writing what that fee is going to be. And then, of course, get the signature of the payor. Whoever you're expecting to pay at a minimum, you're going to want to get their signature on that document. I do get a lot of questions about email. You know, could you send an email? Is that considered a writing? An email certainly is considered a writing, and it's certainly better than nothing. Ideally, you'd have a separate agreement, but you know, in the interest of time or expediency, you could send an email to the person that you are expecting to pay you, memorializing the items that I just described above in the email, and then requesting that the person reply to that email and consent to the terms of the email. That would be considered a writing. If you had to sue somebody over that, that would be admissible, and certainly evidence of the party's intentions in the transaction. And so, a lot better than nothing. But at a minimum, get something in writing, either an explicit commission agreement as a separate document, or some sort of an email to memorialize the party's intention if you're dealing in anything that is outside of your own MLS or outside of an MLS with whom your MLS has a separate cooperating agreement. So very important stuff, because otherwise all that good work you might do on behalf of your client could be for naught if you don't memorialize it. All right, hopefully that's helpful. As always, the Colorado Association of Realtors legal hotline is available Monday through Friday, 9 to 12 and 1 to 4. If we can answer questions there, we're always happy to try and give you some guidance and additional tips there. Thank you again for joining us for another edition of Legal Bites. I'm Scott Peterson.